Yes, so to introduce this session on research agenda for the next decade on Indigenous rights, we are super lucky to have Ravna, who is a professor of law at the University of the Arctic in Tromsø. And he is also accepted to be part of the advisory board of LawTransform. So we're very lucky to have this as the first of hopefully many times that you'll be part of us at the Bergen exchanges. But Øyvind.
Thank you, CIDE, for this possibility to present a topic that is very timely for human rights and rule of law for indigenous people. As it's written in the introduction, indigenous people's rights are protected in international human rights documents as well as in domestic law, but are regularly rendered ineffective by powerful interest and even by the states. This is what I'm going to speak about in this keynote. In other words, the legal limitation international law places in intervention when Norway comes in indigenous cultures, land and resources, based on case law by the Human Rights Committee and also the Supreme Court of Norway. You know, sometimes the Supreme Court support us, other times they have come to another decision. It's a little bit problem that my picture come in front of the PowerPoint. I will give three brief examples from Norwegian law, which shows the gap of fulfilling the commitments. And finally, I say some words, what can be done. Yes, thank you, that was better. First, I will briefly start with internal Norwegian law and a fundamental change in 1999. That year, Norway adopted the Human Rights Act. The Human Rights Act incorporated the 5 most important human rights conventions into Norwegian law. One of them is the International Covenant on Civil and Political Rights. And most of my speech will be about that limitation to Norwegian law. Because that convention shall take precedence over any or other legislative provisions that conflict them. In other words, it's have precedence over all other Norwegian law except for the Constitution. The Article 27 reads, in those states in which ethnic, religious, and linguistic minorities exist, persons belonging to such minorities shall not be denied right in community with other members of the group to enjoy their own culture. This is an individual right for people who is a member of the indigenous communities. And the question is just how to avoid that intervention in a traditional indigenous land, natural resources are not violating Article 27. The decisions or a statement from the UN Human Rights Committee is very important. Most of their practice, or at least the most interesting, come from Latin America, as the Puma case from Peru, which I will quote from here. There are admissibility of measures which substantially compromise or interfere with the culturally significant economic activities of an indigenous community depends on whether members of the community in question have had the opportunity to participate in the decision-making process and whether they will continue to benefit from their traditional economy or livelihood. In other words, they should continue to live from husbandry or other traditional industries. In addition to participation, the committee considers that participation in decision-making process must be effective, which requires not mere consultation, but the free, prior, and informed consent of the members of the community. So that is important. And there is, of course, no doubt that the Sami reindeer husbandry falls under the concept of culture, and that land use for the Sami reindeer husbandry is a part of the material basis, which also is protected by the convent. In other words, culture manifests itself in many forms, including the particular way of life associated with the use of land and resources, especially in the case of indigenous people. Very important to remember, and also important to remember that this is Norwegian law too. Article 27 thus implies that even if an intervention undoubtedly does more good than harm for the society at large, as the Norwegian Expropriation Act says, and even if the individuals affected receive full compensation, the intervention will nevertheless be unlawful if it has a substantive negative impact of the possibilities for minorities to exercise their culture. Now I jump into case law, and I will try to go through two important cases. One of them is the Fosen case, which I suppose most of you know, where the Norwegian state allowed 151 wind turbines to be built in the reindeer husbandry area of the Sorten Sami culture. Here we are. You should be aware that this is in the middle of Norway, closer to Oslo than it, for example, are to Tromsø. The Norwegian Supreme Court repeated the Human Rights Committee, stating there will be a violation of rights of Article 27 if the interference has a substantive negative impact on the possibility of culture enjoyment. In my view, said the first voting judge, the rights of Article 27 is in any case violated if a reduction of the pasture deprives the herders of the possibilities to carry on a practice that naturally can be characterized as trade or as a livelihood. In other words, he should have income from doing reindeer husbandry. It's not enough just to have possibilities to herd a few animals. The conclusion of the Supreme Court is therefore that the license decision to accept building the power plants violates the reindeer herders right under Article 27. The license to run the power plant is therefore invalid. So just briefly, what is the requirement for not violating? The cumulative effect of the old intervention, also the previous one, must be taken into account. Consultation must have influence on the decision. The minority must still benefit, could live from their traditional economy. And if there is mitigation measures trying to solve the case afterwards, they must be culture sensitive. They must be a part of what is reindeer husbandry, not turn it into something else. Just briefly, I suppose most of you know the history afterwards. The Norwegian state refused to follow up the Supreme Court decision, and it was not before the Sami yacht blocked the doors to the energy ministry in Oslo, and the prime minister thus had to recognize that it was a human rights violation, that it was real focus on the case. But even then, the power plants continue to roll. And under a promise of access to alternative pastures, which in fact doesn't exist, the matter was resolved through agreement on monetary compensation. So in fact, there is no difference between the Norwegian expropriation case, which thinks that everything can be solved with money, and what is the outcome in this case, except for probably that the compensation was a bit higher. I have another case, and I know that I have not very much time to go through, but in 31st of May, the Supreme Court heard the Karasjok case, which is based on a process of identifying and recognize Sami land in the Finnmark Act. And it's been a process going on since 2011, where both an investigation commission, the Finnmark Commission, and the lower court, the Land Tribunal, have found that the local people has property rights to their traditional area in the municipality. In other words, the outlying fields, which for a long time has been assumed to belong to the state. The Supreme Court didn't agree on that, despite the fact that ILO 169, which Norway has ratified, state that ownership over the lands which indigenous people traditionally occupy shall be recognized, and that the people in Karasjok undoubtedly both are indigenous and have occupied that land for hundreds of years. The majority of the Supreme Court did not recognize their property rights. As mentioned, ILO 169 was ratified as Norway as the first state in 1990 and is incorporated as Norwegian law through the Finnmark Act, but it doesn't matter much for the Supreme Court. What is interesting is that there was a big minority of the case. This was a Grand Chamber case with 11 judges, and 5 of them didn't agree with the majority. The minority of the Supreme Court find that if national rules applied on Sami premises should not provide a sufficient basis for recognizing property rights, this will in any case have to be the result when national law is applied in light of the human right presumption principle. That principle say that the human right instruments which Norway has ratified, or say another way, that Norwegian law should be interpreted in the light of human rights instrument Norway has ratified, but not in this case. Then I have one slide left, and this is what was the big surprise yesterday. This is the Jobs Ante Sara case, which was hot in 2017, and which nearly most of us has forgotten. In my recent book about Sami and reindeer husbandry right, I even take out that part because it's so long time since we have heard about it. But yesterday there was, I will say, surprising news. In contrast to the lower courts, the Supreme Court of Norway in 2017 did not find that human rights law had been violated in the case. And the case was that the reindeer administration, the state reindeer administration, decided to cut down the herd of Jobs Ante Sara from 116 animals to 75. The Norwegian Supreme Court argued that there was a distinction between cases concerning industrial intervention as wind power plant construction in reindeer husbandry areas, and measures that are in the interest of the minority as a whole. Because here they say that it was in the interest of the minority to cut down the reindeer herds because of the ecological issues, the overgrazing, which they call. Yeah, here is Jobbsante and his lawyer, Trond Beatty. And that is the news. This position have now been set aside by the Human Rights Committee in the case Sara versus Norway, which was published 24th of July 2024, but just yesterday was known to us here in Norway. So the Human Rights Committee has, among other, criticized Norway for not involving the Sami community in the decision-making process. They also say that it's not possible to argue that there is two types of intervention. So Norway has thus, I will say again, violated international indigenous law by deciding that Sara had to reduce his herd from 116 animals to 75, which meant that he can't live from his reindeer husbandry. No, we at least should hope that he's giving his possibilities to do reindeer husbandry back. Yeah, I think I run out of time, and I will not try to answer that question now, but that is, of course, only to say that international law had to be respected. Norway cannot go on to sign documents quicker than the neighboring countries as Sweden and Norway, and later on say that we have a flexibility to interpret it in our way, so it's okay that we follow our national law. Okay, that was the end. So thank you for the attention.
Thank you, Øyvind, very much for this this presentation, which opens many comparative reflections for a lot of the work I think many of us have been doing in other contexts. So this panel is to be thinking about a research agenda for the next decade around Indigenous people's rights, in line with, we've done lots of work from LawTransform in the different projects, working on questions of Indigenous rights protection in international law, in domestic law, in case law. And we have three speakers. Tatiana is somewhere on there? Online? Okay, wonderful. Those of you who are looking at the program, I'm afraid Guillermo's already had to leave. So we're going to go in the order of, and then I'll give the word also back to you, Øyvind, about future directions, because you didn't have time to get to that. And give the floor first, because we have little time, to Marília Siqueira de Costa, who's from the Universidad de Sao Paulo. So, Marília, please.
Okay. Good morning, everyone. I am very happy. It's a pleasure to be here at the Bergen Exchange, mainly to discuss the research agenda about the indigenous rights for the next 10 years. I'll talk about a little the Brazilian context. The issue of indigenous territorial regularization will continue to be faced in the next 10 years because there are 730 indigenous lands in Brazil and 250 needs regularization yet. And in the fight for demarcation, have been faced with new obstacles every day. Today, the main challenge in discussion in Brazil is about applying or not the time frame criterion that we call marco temporal theory. That theory established that only lands occupied by the indigenous peoples on the date when Brazilian Constitution was enacted would have rights to the territory. So in this way, indigenous peoples who were expulsed from their lands over the years, especially during the dictatorship, would not have their rights recognized. But in Brazil, we also need to extend the debate to all the traditional communities, because we have 28 segments, such as the quilombolas. They're like Afro-descendants with a special relationship with their territory. So these communities are also fighting to remain in their territories, in their lands, and they face even greater obstacles due to a specific legal regime established for the regularization of their territories. In their case, different from the indigenous peoples, the government needs to pay a compensation to the private owners for the territories recognized as traditions. So for this reason, the scenario is even more serious. Out of 7,000 quilombolas territories, only 147 have been regularized. A recent study showed that if the current pace of the regularization is maintained, the regularization of quilombolas territories will take 2,000 years to be finished. So, as long as indigenous peoples and other members of traditional communities are dying or have their lives threatened because of the struggle of territory, this issue must be continued to be faced at the center of the debates. In addition to the regularization of the territory, other subject is the enforcement of the prior, free, and informed consultation as provided of Convention 169, and especially also in Brazil about the clean energies with the installation of the wind towers. We have the same problem, especially with the quilombolas territories. And the companies tries to give money to part of the members of these communities, try to weaken the collect action. So they give money to a part of members and don't give to another. So is a very good strategy. So because of this, in the case of the clean energy and the case of other forms of exploitation, is essential to think about alternative strategies of defense in addition to go to courts, such as a possibility of including in the context of compliance or ESG, environmental, social, and governance, the existence of violation or not of the rights of traditional communities, like a way to protect, not only to go to courts. I have 10 minutes.
You have 1 minute.
Okay. Finally, I want to add the subject of my PhD research that's about equal access to rights in Brazilian traditional peoples and communities. And my research, the main is to verify whether the complexity of the legal system and the normative text with their rigid delimitation of requirements prevents realization of rights by these communities, since they are drawn up for and by members of the hegemonic society. Oh, so there I stop. I think I finished this time.
Right. Thank you very much, Marília. I failed to mention that both Marília and Israt are doing the PhD course here this week. So we're very delighted to have them here. So Israt, the floor is yours to tell us your take. 5 minutes, please.
Hello, everyone. Thank you for the opportunity to speak up today. So I'm doing my research paper for this PhD course in the indigenous people, their land rights against the oil extraction that has the Ecuadorian government has imposed. And so when I was doing the research, I found out that the one thing that all the laws, rights, and regulations are only mentioned in the paper. It is only written down, but it's a whole different story when those rights are not respected in real life. So this is a challenge that many indigenous communities face around the world. So here's some brief story on the Ecuadorian context is that in 1960s, there was a discovery of oil in the Amazon that has marked the beginning of a new area of the environmental and social challenges for the indigenous people. And the Ecuadorian government, in pursuit of the economic growth, has granted numerous oil extractions in Amazon, often without the free, prior, and informed consent of the indigenous communities. So the Warani people who lived there, once isolated and autonomous, had to confront the encroachment of oil extraction and the oil companies on their ancestral lands. So this confrontation has led to numerous legal battles, like they are protecting their rights and to preserve the land from exploitation and environmental degradation. So we all know that their rights are recognized and protected by human rights frameworks and also their national or domestic laws. But despite these protections, their communities face tremendous challenges in realizing their rights on the ground. Like these rights are undermined by powerful interests, whether it's governments pushing development projects, corporations exploiting natural resources, or even legal systems that prioritize other concerns over indigenous justice. So while I was writing this paper, I found some serious concern that raises fundamental question that under what conditions do laws designed to protect indigenous peoples truly work, and how can they move beyond paper promises to make a difference in people's lives. So I was reflecting on the future research prospects that we need to focus on the intersectionality of indigenous rights. And we know that they are not a monolithic group. Their identities are shaped by intersections of race, gender, class, and environment. So for example, like indigenous women often face challenges for being marginalized both as women and as members of their communities. So to create effective legal protections, we must understand these intersecting identities and specific vulnerabilities. So second, we must explore the role of legal pluralism in supporting indigenous autonomy. Indigenous peoples often lived under multiple legal systems like state law, customary law, and international human rights law. So this legal pluralism can both be a source of strength and a challenge. Like customary law reflects the values and traditions of indigenous communities, but it can be a powerful tool for self-governance. On the other hand, state laws often clash with or override these customary systems. And undermining indigenous autonomy, research needs to focus on how these different legal systems can coexist in a way that truly empowers indigenous communities, allowing them to govern themselves according to their own laws and values. So we should also address the intersection of indigenous rights and environmental justice. We often say that the first indigenous communities are the first to feel the impacts of environmental degradation. They play a crucial role in protecting ecosystems, but their land rights are frequently ignored or violated in the name of development or resource extraction. Like on the climate change, this issue is becoming even more critical. We need research that not only defends their land rights, but also that integrates indigenous knowledge, practices into broader environmental strategies, and that protect the environment and respecting indigenous rights. So finally, I would like to say that protecting their rights in more about than just having laws on the books, but it's all about ensuring that these laws are effective, meaningful, and transformative. Thank you.
Thank you so much, Israt. We're going to go to Tatiana Alfonso now from CIDE in Mexico, who's at 3:30 in the morning, I think, in Mexico City. So Tatiana, you have 5 minutes. 3
Close to
4 in
sunrise.
the morning.
It's amazing.
Well, we're doubly grateful for you.
Yeah. Thank you for all the presentations and for the mini lecture at the beginning. I would say like for 5 minutes and thinking about what we have seen, at least in Latin America, in terms of what we have achieved in terms of indigenous rights. I would say that there's at least 2 main issues that we need to push forward in research and advocacy, which is something that like the victories of indigenous rights under the classic liberal framework has left, of course, aside, which is the first thing is filling out with actual contents the right to self-determination. Self-determination is at the center of indigenous mobilization in the international law since the beginning. It's at the center of most of the claims of indigenous peoples in every aspect of recognition, redistribution, land, climate justice now, access to justice, etc. And yet we don't have actual contents to fill out what self-determination means in different topics. So that's the first one. I'm going to develop it a bit. And then the second one is to focus on structural inequality as the basic problem that we need to solve with rights. So I think that when we think about why self-determination has been left aside, it's very clear when you look at the history of the recognition of self-determination of peoples in international law, and also who have been the actors that have opposed to the development of self-determination with specific contents, it's very clear that the tension and the stakes are very high. So we have a war right now, and we have had a long conflict just because self-determination is the point of what you can do or not, what you are allowed to do in international law. But then, like at least in Latin America, self-determination is always in the middle of the claims. It's always a rhetorical clause. It's always in the middle of the discourse, the legal interpretation, and yet we don't have actual standards for self-determination. So think about judicial independence. As probably as most of you know, Mexico is now in the middle of a turmoil in general, but judicial independence is one of the main issues of the current tensions. And when you think about judicial independence for indigenous communities, for example, legal pluralism is not enough. Coordination between indigenous systems, legal systems, and the state systems is not enough. And we actually don't know what that would mean for indigenous communities, right? So we need to start thinking about self-determination in those terms, right? What's the relation, what's the within group relations and the between groups relations that we need to tackle in order to assert self-determination for judicial independence or for land and territory and for access to justice or climate change, right? So we see a lot of new research funding initiatives, NGOs, research projects on climate justice, intersectional climate justice. I was part of a new proposal, which sounds amazing. Everyone believes in that, but then we need to fill out that with content. It's not only that it's the most affected group of population. It's not only that they have like different solutions or ways to deal with climate change impacts, but it's that we need to understand what that means in terms of self-determination and structural inequalities. And I think that would lead us, if we put in the center those two issues, I think we have more hope, let's see, to push for something that can actually tackle long histories and trends of discrimination and racism and exclusion. So it is about to play with the classic liberal framework, as Elena was saying in the previous panel, and see what we can win under that framework in order to have new contents built with indigenous communities. So I guess that's especially important for land and territory, but not focusing on land. In Latin America, land and territory is a long time recognized right, and yet governance systems, the recognition of governance systems as autonomous is very weak. So I guess we need to pay more attention to governance systems from the perspective of self-determination and structural inequalities in order to work on the other topics, like specific topics: land, access to justice, judicial independence, climate change, etc., etc. And maybe that's a good frontier to pursue.
Right. Thank you, Tatiana, so much. Okay, I'm going to give Øyvind 5 minutes to say what to do.
Yes. Thank you. First of all, thanks for all these 3 interesting presentation, and I think it's a common change nearly all over the world for the indigenous community, that there is a race for energy which will have intervention and destroy the land. Going a little bit back in time, it was oil and coal minerals. Now also the so-called green shift have huge impacts. So I could more and less agree on all what you were saying, Marília, and also Israt. So what I was speaking about today, the Finnmark Act, it's also a process of the demarcating the land of the indigenous Sami and also other local people up in the north, but it's of course become much more controversial than accepted, because there is of course a lot of communities who don't want any demarcation, and particularly the authorities and the state don't want it anymore, even if they have ensured it in the Finnmark Act. So what to be done for the next 10 years? I think there have to be kind of ethic feeling also, that we should in good faith try to follow the international commitments which most of the countries has adopted, at least the ICCPR, which is a part of law in nearly all the states worldwide, and there should be a balance between grabbing up the land and taking care of the indigenous culture. So I think from my point of view, I think we just should urge the state authorities, the lawmakers, and the national courts to follow the law, and of course we need to educate younger people, the lawyers and others in the law. So therefore it's of course very good to see that there is many PhD students focusing on that. So I think I stop there.
Fantastic, thank you. I have so many, very many things I'd like to say, but we have 10 minutes, so I'm just going to open up. We have 15 minutes. Well, I think that the many common issues here that everybody has been pointing to, and also issues around navigating different levels and fora of international law. We tend to kind of say, is international law any use? Not much, but I think many of the stories that we're hearing are about different trajectories. Yes, about developing standards and filling out self-determination, as Tatiana's talking to, I think very much. But I think there's also, it's not just taking care of indigenous cultures. There's a wider debate about care more broadly to be had. And the previous panel was telling us many stories about alternative narratives being put in the public domain, even if the cases are lost. Right? So I think I would like to also broaden the discussion out rather than just the kind of enforcement of existing protections, which is a large enough question in and of itself, but about public space, voice, and narratives, and kind of maybe that will encourage us to be thinking about innovative research in, on, around, with, obviously, Indigenous peoples to come. So I'm going to open up there to the floor and see questions, comments from all of you, please. Okay, 1, 2, 3, 4. Who's got the box? Okay.
Okay, I can speak up. Okay. Okay, now it's over. Yeah. That's thank you. It was such a super good panel, and I also like the PhD students were really connecting a lot of things that I really like regarding intersectionality. So my question is about that. While thinking indigenous rights in Latin America, it's like impossible not to think about like human rights defenders and the violence against them. I'm thinking especially in Berta Cáceres, but now, well, like following the Colombian case, like the most attacked group of environmental defenders are women indigenous, women human rights defenders, right? So if you could tackle this a little bit, like what are like good frameworks, like maybe like the Escazú Agreement, or in order to, protect the people that are fighting for indigenous rights, especially like women that are at the forefront of this. Because in the front lines, like your publication, they all the time show like Colombia as the most affected country for, like the killer of environmental defenders. So how to tackle this? And if you could, give us some clues about it. Yeah.
Thank you very much for an amazing panel. I just wanted to raise a point that I'd like you to comment on, also thinking on, well, we're talking about the agenda for the next decade, which is on the, on indigenous mobilization regarding these issues and on the specificities of control and repression to indigenous mobilization, because I feel that, at least thinking on the Brazilian context, but I think that this applies broadly, since this is a kind of a social mobilization that often takes place in the traditional territories and in areas that are outside the sphere of most visibility, which is the issue of the inequality of visibility that we mentioned in a previous panel. I feel that in Brazil, there are very different kinds of repression that take place specifically. So this is both in terms of how the police is going to act and also about the role of non-state actors in repressing protests. So very often actors such as farmers, miners, will act as if they were police when the local police knows about this and allows for it in a certain way. But since they are not actually state actors, it's much harder to hold them accountable and so on and so forth. So I think this poses challenges to investigate this and to denounce these violations. Thank you.
Thank you. I think okay, then we'll go round and get to you. You could come.
So I think it's just very quick because it has to do with these two questions. I mean, maybe a way of framing this is a research agenda on autocratization and indigenous peoples and traditional peoples. I mean, I think the forms of constructing territory and of worlding that these communities have is at the center of autocratization processes in our countries and across the world. And this has to do with how governments are structured, how governments operate vis-a-vis social movements, and how private repression forces are also organized. So I think that's one promising, unfortunately, research agenda. And the second one is coming back to something that was said about this issue of legal pluralism and the insufficiency of legal pluralism and these frames that we have. But isn't it the case that we now have new frames under which to think about self-determination or legal pluralism, which is this climate change, Anthropocene? Doesn't all of this cast a new light on our need for indigenous forms of worlding and ontologies and also legalities? So isn't this a way of going back to research agendas that we've had for a long time, such as legal pluralism, under a new light, and thinking of how this plurality, how these different forms of law produce the kinds of ecologies that we need in the world? So maybe this is a new way of framing old questions.
Krista.
Oh my God, that's far away. Ready?
Sorry, I couldn't help that. You okay? Okay, so this wrong way, right way? Yeah, so thank you. It's right way, yeah. So I mean, when we talk about public space, you know, it's all good and well to hear about research agendas, but I would like us to focus also more on capacity building and teaching, because you know, a number of us do teach. Øyvind has been carrying around his big book, you know, who's going to read that? Who's going to learn from that? And, you know, Norway has 6 faculties of law. And I'd like Øyvind to say something about the specific situation. So where is Sami law taught? Who has the capacity and who doesn't have any kind of capacity? And, you know, Norway is a country founded on territories of 2 people. How come it's literally invisible anywhere but Tromsø? And I'm gonna, easy.
No danger. I just had a question that kind of speaks to some of the points that all of the panelists were making. You know, you talked about the need for an alternative strategy beyond just the courts, or a means for ensuring the respect for Indigenous rights beyond just paper, or the need to flesh out the content of what self-determination actually means. And I wondered if any of the panelists have any thoughts on the promise of looking at forms of Indigenous direct action. Even you talked about the blockading of the energy ministry, for example, as a form of lawmaking, a claim to state, as Christian Lund might say. Yeah, what is the promise of looking at these sort of subversive acts of lawmaking, you might say, of Indigenous land justice activists or land defenders? Yeah.
Thank you. Anna and Ruth, right?
Okay,
Sorry,
thank you.
Anita.
Yeah, my question was about, well, it's in direct relationship with what was you were saying about autocratization taking into account, but also what, at least for my, with my fellows, Indigenous fellows in the research world, the need to go beyond these categories too, because it's not because democracy or autocracy or the left and the right. Finally, I think that the matrix to be studied is extractivism in its every form. So what about just not talking about democracy or autocracy or left and right government, but other kind of structure to be studied?
Namita?
Namita.
I had a question about the Finnmark Act. So, you know, I was just listening to you and also reading about it. It seems that, and it's also a question to do also with representation and participation, some of the things that we were discussing in the previous panel. So the first, so if I understood correctly, even though the Act recognizes rights to land, it does not recognize rights to fishing, mining, and the oil resources that are there in the region. And that, So in that sense, am I right to understand that it is a sort of limited recognition? And the second is about institutional mechanisms of representation and participation insofar as the control of the resources, the members of the Sami parliament. How has that worked? Because, for example, in India, we have had these autonomous district councils, which are supposed to have representation from the tribal community since the last 75 years. But the problem is that a lot of times these are non-functional, there's financial crunches, and they're not really responded to. And so I was just wondering whether having an alternative Sami parliament is a better structure, or is it to have structures within, the thing, in other words, representation within the Norwegian parliament, like reservations for Sami people within the parliament and so on. And I just also, to add to Anna's point about extractivism, I was wondering what the global flow of capital. The interesting thing is that, we've always been over the last, if I look back, instead of looking forward for 10 years, if I look back at the last 10 years, a lot of these issues we were talking about as a result of flow of financial capital from Western countries into the global South. But I was curious to know what that is, because a lot of the financial capital is based off oil and mining and things like that also within these countries. Like, it's interesting in a way that it's the capital itself is being generated on these rights of indigenous groups here, and then it is being used to take away rights of indigenous groups back home, because we have more capital now to do mining in our countries, thanks to the integration of the financial markets. Thank you.
Last, I think, too. Yes.
So I was wondering whether one of the items in the agenda could be Indigenous women as such. I mean, you hear them as victims, but I think not just as victims. I mean, there's a whole movement, I think, of empowerment. And I simply ask myself the question, if it was Indigenous women deciding the agenda, would it be exactly the same agenda? Would it be different? So I think that's a whole fruitful area, and some things that were not traditionally too much discussed, like sexual violence in Indigenous communities, are now coming to the fore. So I think there's room for that.
Thank you. We are out of time. As it is. And there were so many questions that I think if we start to answer them now, we will not keep the time. So I would just encourage everybody to go get a cup of tea and coffee and to continue to discuss amongst the panel and yourselves. Thank you.